Welcome to Fighting for What's Right. I'm Pam Jones, here with personal injury attorney Barry Doyle. Barry, if you're going to try to settle out of court, what happens?
Well, the starting process for it is always going to be that you're going to make a settlement demand to the insurance company. That demand needs to be made well in advance of whatever your statute of limitations is going to be. Your statute of limitations for your typical personal injury case is going to be 2 years from your date of accident, unless there's a municipality involved, in which case you're talking about a 1 year statute of limitations. So the timing on it is always going to start with what's your end date for the statute of limitations, because you don't want to be left in a situation where you haven't filed suit and that statute of limitations is coming up. But if you have the time to work with it, then certainly the starting point of the discussion is telling the insurance company, we're willing to settle for this amount of money, whatever it is. Now, before that demand goes out the door, I have a discussion with the client about what they're willing to accept, because in the end, it's the client's case, it's the client's life, it's the client's decision, and they get to make these decisions based on their own goals, their own values, their own tolerance for risk. But once I have that discussion with the client about what do they want when everything is all said and done, then we make a settlement demand that gives us some room to negotiate downwards.
Okay, and when you're talking about this demand letter, what kinds of thinking goes into that? What kinds of aspects of the person's life are you discussing?
Well, to begin with, they have to be done with their medical treatment, in the sense of either they're all better or they're as good as they're going to get, because part of what goes into this is going to be their medical expenses. And if the medical expenses are either ongoing because they're still getting care, or if they're going to need ongoing care on a permanent basis, then we need to have control of what those numbers are, because that really is a big part of the equation. When
it can't be open-ended, in other words.
Right, exactly. The clients are going to sign a release that is going to settle the case. It's going to cut off their further rights to recover additional money. This is something that I wrote a report on that's actually in the Resource Center. It's called How Much Is My Case Worth? It talks about this whole issue of how do we go about evaluating cases. And it really is one of the basic kind of crucial skills that somebody who really knows what they're doing when it comes to this kind of work brings to bear.
So Barry, you mentioned this free report, How Much Is My Case Worth? Can you tell our audience how to find it?
It's www.fightingforwhat'sright.com. And there's a section in the website called the Resource Center, where there are a number of free reports. How Much Is My Case Worth is one of them, but there are a number of others that are available for free instant delivery by email.
So Barry, once you evaluate the case, what's the process for actually getting the case settled?
Well, as I said earlier, the starting point for that is going to be the demand. This is how much money we're willing to take. And one of the interesting things about trying to settle cases is that, it's almost like selling a house. There's a certain amount of money that you're willing to take to sell your house. There's a certain amount of money that you're willing to take to settle the case. And it's sort of your bottom line. And let's just say that you really want $100,000 to sell your house. You might list it at 110 and think, well, if I can get 103, I'm doing really great. In our line of work, if you want $100,000, you start off with a settlement demand that's much, much higher.
200?
Usually a lot higher than that. So it's usually like 275 or 350.
So times three almost. Is there a times three rule?
No, there really isn't a rule for that, but you build in plenty of space to negotiate your way downwards. Making a demand, if you want 100,000 for 110, really sends a signal to the insurance company and to the defense lawyer that you're thinking about a number considerably less than 100,000. And there's sort of this silly dance that lawyers go through. I start off with a $275,000 demand, and they come in with a $20,000 offer. And eventually, everyone sort of negotiates their way back to something that's within the bounds of reason. And if not, people tend to get very focused in on getting the case settled, literally after you've already answered ready for trial. Settling on the courthouse steps is a cliche. It's a cliche for a reason. It happens a lot. And I had 1 year where I answered ready for trial 7 times, and none of those went to verdict because once we answered ready for trial, there were actually serious, meaningful discussions about settling the case, and the cases were resolved for the kind of money that was appropriate for the clients and met the client's needs and desires. But it took that long to get to that point.
Thanks, Barry. This is Fighting for What's Right with personal injury attorney Barry Doyle. For more information, visit our website at www.fightingforwhat'sright.com.